Hello, my name is Heidi Boudreau. I'm a solicitor at Stewart McDonald Stewart, and over the next few minutes, I'm going to be talking to you about some upcoming and proposed legislative changes that will have an impact on local government procedures and practices. These changes include amendments to the Local Government Act, Community Charter, and Vancouver Charter to make virtual meetings and other tools implemented during the COVID-19 pandemic permanent, amendments to the Local Elections Campaign Financing Act, and amendments to the Criminal Code with respect to firearms. The first area of legislative change that I'm going to be discussing is the Municipal Affairs Statutes Amendment Act 2021. As noted, this Amendment Act includes amendments to the Local Government Act, Community Charter, and Vancouver Charter. This past year has been filled with many challenges, and we're now finally at the point where we're beginning to see the light at the end of the tunnel. And we are getting the chance to consider some changes that were helpful during the state of emergency and areas where legislation would have made the challenges easier. The purpose of this act is to implement some of the COVID-19 emergency measures that were put in place on a more permanent basis and provide tools that will allow the province to assist local governments in any future emergencies or extraordinary circumstances. The proposed amendments include amendments to electronic meetings and public hearings, mail-in ballot voting in elections, the authority of the Minister of Municipal Affairs to adopt regulations. So the first amendment I'm going to discuss relates to electronic meetings and public hearings. Meetings will continue to be permitted to be held by electronic facilities, provided that the local government authorizes the electronic meetings by its procedure bylaw and includes provisions in the procedure bylaw identifying the notice requirements for meetings held by electronic facilities. The local government has the electronic facilities that will permit participants to hear and watch the meeting, and there is always a designated officer in attendance. Public hearings may be conducted by electronic means if the notice indicates the means of electronic facilities and participants will be able to hear and watch each other. Another area that has been a relevant topic in this past year is voting by mail-in ballot. The bill includes a provision that expands the eligibility for mail-in voting by removing the restrictions on who is permitted to vote by mail-in ballot in the Local Government Act. Local governments will be permitted to authorize mail-in ballot voting by bylaw. The only difference is that there will be no constituents who are restricted by participating in the elections by this means. A third area of amendments that relate to considerations that came to light in the COVID-19 pandemic is the authority of the Minister of Municipal Affairs to adopt regulations relating to loss of revenue, repayment of debt incurred from revenue anticipated borrowing, and elections. The minister may also only adopt these regulations when the regulation is necessary to prevent, respond to, or alleviate the effects of special circumstances. Special circumstances are not defined in the Amendment Act. However, it would likely include any future local or provincial states of emergency. This bill was given its third reading on June 1st and has not yet become law. The intention is that the Amendment Act will come into force by regulation once the current emergency orders are lifted. Amendments to procedures bylaw can only be adopted once the Amendment Act has come into force. Therefore, if you're looking to amend your procedures bylaw within your local community, keep an eye on these changes in the coming months as to when you will be able to adopt. Another area of legislative change relative to local governments, especially as we get closer to the 2022 election, is the Local Election Statutes Amendment Act. The primary purpose of this amendment is to amend campaign financing goals to increase transparency with respect to raising campaign funds during an election, or in some circumstances prior to the election. The act will apply to local elections starting in October 2022 and all subsequent by-elections, except for the changes regarding sponsorship contribution limits, which I will comment on later. The amendments include new rules for electoral organizations, election advertising, investigation and enforcement of election rules, monetary penalties, and encouraging participation. Electoral organizations must now register with Elections BC in order to accept campaign contributions, endorse candidates, and incur election expenses. In addition, electoral organizations will be required to file an annual financial report with Elections BC. With respect to election advertising, the pre-campaign period during which election advertising is regulated will be increased from 29 days to 89 days. This means that 89 days before elections, any billboards or commercials will need to identify the campaign sponsor. In addition, third-party advertising or election advertising sponsors, i.e. individuals or organizations that sponsor election advertising independently, will be limited to a maximum of $1,200 in contributions, the intention being to limit potential influence of large donors. The $1,200 cap also applies to sponsorship contributions during provincial elections. With respect to investigation and enforcement of election rules, the BC Chief Election Officer will have an increased ability to investigate and enforce violations by allowing the Chief Election Officer to request records from companies that deal with online advertising and allow for court orders to request records from financial institutions. With the new rules and investigation and enforcement mechanisms, there's also the authority for monetary penalties. Elections BC will now have the authority to issue monetary penalties for 50 or more violations, including failing to register as an electoral organization, failing to include sponsorship information on election advertising, and accepting prohibited contributions. The last area of legislative changes relates to encouraging voter participation. The requirement that a participant must be a resident of a community for 30 days prior to participating in elections has now been removed. In addition, candidates and representatives will be able to access strata properties for the purpose of canvassing and distributing candidate information. This is an important change for encouraging voter engagement in our increasingly population-dense communities. Another legislative change that could be relevant to BC local governments is Bill C-21, an act to amend certain acts and to make certain consequential amendments with respect to firearms. This is a federal act, and the stated purpose of Bill C-21 includes helping municipalities create safer communities. The act includes amendments to the criminal code that will make it a crime for individual license holders to store or transport firearms in a manner that is inconsistent with a municipal bylaw that regulates the storage and transport of firearms. The penalty for this offense will be a maximum of 2 years imprisonment as well as revocation of the firearms license. If a local government wishes to take advantage of this provision of the criminal code, it will be necessary to provide notice of the bylaw to the federal minister, including information that will be set out by regulation. 180 days after notice is given to the federal minister, it will be an offense in that local community to carry or transport firearms in a manner that is inconsistent with the bylaw. It'll likely be some time before these changes impact BC communities. This bill still needs to be reviewed by the Senate before it becomes law. In addition, in order for British Columbia local governments to take advantage of this new protection, there will need to be amendments to the Local Government Act and Community Charter. Currently, the Community Charter and Local Government Act permit regulation and prohibition of the discharge of firearms within the area of the municipality or regional district. However, there is no authority to regulate or prohibit the transport or storage of firearms. Therefore, there will need to be amendments to both of these acts to take advantage of these new provisions. The previously summarized legislative changes will be relevant as local governments transition out of the current state of emergency, looking forward to the 2022 local elections, and further down the road when or if the federal and provincial government allow local governments to regulate the storage and transport of firearms. Thank you for the time you've taken to listen to my presentation today. If any of the points I've made raises questions for your local government, please don't hesitate to get in touch with us here at Stewart McDonald Stewart. You can visit our website where you'll find lots more information relevant to local governments, or you can contact me directly via email at hboudreau@sms.bc.ca or call us at 250-380-7744. Thanks again for watching today's webinar.